Hi, everyone. Welcome to the session on live virtual classes of Board of Studies ICAI for the CA intermediate course. And we are dealing with the paper on corporate and other laws. And we have been covering the other laws part and in interpretation of statutes. That is the topic which we are covering. In the last session, we dealt with the part of it. And today we are going to complete this. So this 4 lecture series on the other laws will complete today. So would be happy to take all the questions which you have on both these papers, interpretation of statutes, as well as your topic on general principles of them. So we will try to see number of examples. I have with me a book on interpretation of statutes by Justice G.P. Singh. So I will try to, bring some more examples from this particular book so that it becomes more clearer to you. That is the objective. Try to understand one thing in this very clearly is that interpretation of statutes is not a, mathematics kind of a thing. It is not having 1+1 formula kind of a situation, or it is not accounts. It is something which has to be holistically seen. It has to be, you have to look at the spirit of the law. You have to try to go into depth of it. You have to make sense from the language. So it is a kind of, art and science both. That is what it is said. So interpretation is art and science both. And try to understand the concepts which I am going to tell you from that context. Okay, so keep your mind a bit open and innovative in thinking. So it may on certain points you may feel that this interpretation is not right. So there is no harm in that. Okay, because interpretations can go in different ways, but there are certain norms and rules which we are going to have a look at it, and which we have already seen. One has to only stick to those particular rules, and we have seen those particular rules basically, and I will repeat for your convenience in a short while. So moving ahead and talking about the learning outcomes of the chapter, you have seen this particular red portion we have already covered. That is primary rules, secondary rules. We try to understand what is the importance of the interpretation of statutes. And you have gained knowledge about the need of interpretation of statutes, and you should be in a situation to explain the various rules of interpretation of statutes. Today, we are going to cover internal and external aids, as well as briefly touch upon the basic rules of interpretation of deeds and documents, which is not different than what primary rules we have seen. Okay, so those rules also apply to deeds and documents, other than a specific rule of consensus ad idem, which is the basics of contract or deeds, right? So whatever a deed or a document is drawn upon, the consensus of parties, the ideas of parties is very, very important, and that should be reflected in the document. Then only that document will be valid. We will talk about that also. Moving ahead, I told you about the basic principles, and I told you that when you are making the interpretation, you need to always remember in mind that you have to ultimately go back to the intention of the legislature. That what is the intention of the legislature? What exactly the legislature wants to do or tries to do? And in doing that, you have to read the statute as a whole. So you cannot pick up a line from a statute and interpret the way you want. You have to see the overall structure of the statute. You have to see the objective of the statute, and then only from there you derive the intent of the legislature. The basic rule also we saw is if meaning is plain, effect must be given, irrespective of its consequences. So consequences may be harmful, consequences may be harsh, consequences may be rash, but the plain meaning has to be given the implementation, and that is the basic rule. But at times, you will find that there are conflicting provisions, and statute, the two provisions in a statute is at loggerhead. Then in that situation, you need to find out a way to constructively and effectively make it workable. So this is something which you need to, familiarize yourself to and try to understand that the statute works in a particular way, right? So this is what the basic principles which we dealt with and talked about in our previous class. If you would recollect, in our previous class, we dealt with primary and secondary rules. And particularly, I told you that there are four basic rules of interpretation, which may be called primary rules. And the three rules which you find in primary rules here mentioned in your course syllabus is a additional support or a way of interpretation, you can say, or way of construction that is beneficial construction, exceptional construction, and agisdum generis. And we also saw the secondary rules of nocere soci and contemporaria exposito. These two things which we discussed also. Apart from it, I gave you some additional material also. Please refer to the PowerPoint presentation, which I have already uploaded on your portal, admin portal. Now coming to this particular four rules, the basic rules, you start any interpretation with a literal rule. So literal rule basically means that you read the statute as it is. You don't add any words, you don't take away any word, you give the normal meaning of the terms and words which have been mentioned in the statute. This is what is called literal construction. But many a times, when you are doing a literal construction, you may find some absurdity or you may find an ambiguous provision. Then in that situation, you need to provide a reasonable construction. And that is why this rule of reasonable construction is also referred to as golden rule of interpretation. So this is the golden rule of interpretation, because many a times in literal construction, you will be stuck up. So you need to move forward and try to understand, reason with it, that why this provision is like this. Then in many situations, you will find that there are conflicting provisions, or there are provisions which are not in sync or synonym of the parts of the section, or maybe two sections or maybe two subsections are not going properly. Then in that situation, you apply the harmonious construction. This is the another third important principle or rule of interpretation. And finally, we also saw about mischief rule, which is basically the rule which was laid down in Hayden's case. And we discussed this case at length. And we try to understand what this mischief rule is. There are four factors which are given in the mischief rule. And we saw that those particular factors, that you try to see that what was the status of the statute which was before the law or the rule came up. What problem was there which the rule tried to remedy, or the mischief, what kind of a mischief was there which the rule tried to remedy, and what is the solution which is given at present, and whether that solution is serving the mischief or curing that mischief or not. This is something which you basically follow in the interpretation of mischief rule. So these are the things which we discussed in our previous class, and I told you that we need to now look at the different aids to construction. As I told you before, there are two kinds of aids. One is internal aids to interpretation or construction, and the other one is the external aids to construction or outside support. So you can say internal aids, as the name suggests, this is something which relates to the statute itself. As you can see in this particular diagram, which itself is there in your course material, you will find long title, preamble, heading, marginal notes, definitional sections, illustration, proviso, explanation, schedules, and read the statute as a whole. This is the principle. You recollect? This principle is also talked about, but this is not actually the internal aid to construction, but this is a principle. So this principle has been mentioned here as internal aid, but this is principle basically. So we will talk about each one of this one by one, okay? And try to understand with example as to how these internal aid to construction works, okay? But before I proceed, if there are any questions till now, you can ask me on the admin portal, or maybe you can ask me here in the chat box also. I'll be happy to answer any questions which you have here. So you can utilize the chat box, or you can utilize the admin panel. Let me check that admin panel, and then I will be happy to answer your questions. Okay, statutes basically means the law. Okay, that is what, or the act, that is called statutes or I have given you the explanation of statutes in my previous class. If you see there, we have talked about different types of statutes, enabling statutes, remedial statutes, like that. Okay. Now let us move further and talk about aids to interpretation. Now, what does the word aid mean? Aid is basically, if you see the dictionary, it has got synonyms of assistance, support, help. So an aid is a device that helps or assists. So in interpretation, aid is a device which helps or supports the interpretation. So whenever the judges are there to interpret a law, they need some support. Support is not always needed. Many a times things are very clear. You don't have to, get the support. The section itself is so clear. And most of the times this happens. Okay. So statutes generally, and there is a presumption also towards, simplicity, that whatever is mentioned, that is what is the basics of literal interpretation also. That if you have mentioned something in the statute and it is readable, you go ahead with that. You don't require any aid of further interpretation in it. Okay. Now, for the purpose of construction or interpretation, the court has to take recourse to various internal and external aids many a times. Here, internal aid means those material which are available in the statute itself. So if I am talking about Indian Contract Act, anything which is there inside the Indian Contract Act will be referred to as internal aids to construction, though they may not be part of the enactment. And there are many things which are not part of the enactment, but still they are part of the statute. We will see those in a while. These internal aids include long title, preamble, heading, marginal notes, illustration, punctuation, proviso, schedule. There are many transitory provisions, etc. When internal aids are not adequate, court has to take recourse to external aids. Whenever the court are not able to find internal aids or they don't get any support from the internal aids, they will move towards the external aid. Now, external aids may be parliamentary material, historical background, reports of a committee or commission, like for example, Law Commission of India, official statement, dictionary meaning, foreign decisions, etc. So we will see all these internal and external aid in our coming slides. In one of the decisions, Justice Chinnappa Reddy said, that was basically B. Prabhakar Rao versus the state of Andhra Pradesh. He said, where internal aids are not forthcoming, we can always have recourse to external aids to discover the object of the legislation. External aids are not ruled out. This is now a well-settled principle of modern statutory construction. This is what O. Chinnappa Reddy said. And that is how the external aids are now being referred. And many of the external aids are now referred. If you see the latest Supreme Court decisions, they are often referring to the committee reports. I'll give you one example. For example, Insolvency and Bankruptcy Code. See the decisions of the Supreme Court on Insolvency and Bankruptcy Code. They have copiously quoted T.K. Vishwanathan committee report. They have looked at the international scenario. They have seen the historical background of the legislation, why this legislation came up. Similarly, if you will see CCI versus SEL, they have in detail gone back to the history of the law and seen from the SVS Raghavan committee report or MRTP commission how it has acted. It has seen the different objectives and philosophy, the arguments. In fact, if I'm not wrong, in one of the decisions, they have also referred to the parliamentary debate. So this is how the external aids are taken into consideration. But now let us focus on internal aids and go one by one towards the different aids. Now, before we move on to that, there is a cardinal principle of construction that external aids are brought by widening the concept of context as including not only other enacting provisions of the same statute, but its preamble, the existing state of law, other statutes in pari materia, and the mischief which the statute was intended to remedy. That is what Supreme Court said in District Mining Officer versus Tata Iron Steel Limited. So this is with reference to construction, that how external aids can be utilized. Now here you will see there is a term which is used, pari materia. This word you will find many times in the interpretation. So what does pari materia means? So the legal principle of pari materia is basically on the same subject matter, is used when interpreting statutes or laws that are related to each other in terms of subject, purpose, or objective. The rule suggests that the law dealing with similar subjects should be interpreted harmoniously and achieving consistency, so that achieving consistency. Now, this is very important aspect which is there. So now, if I move ahead and talk about the other part of it, see, the IPC defines offenses, while the CRPC lays down procedural rules for handling offenses. Since both statutes deal with criminal law, courts often interpret provisions from these codes harmoniously under the principles of pari materia. So these, wherever there will be an interpretation required in these two legislations, they will look for, for interpreting IPC, they can refer to CRPCs. For CRPC, they can refer to IPC because they are considered as cognate legislations. Okay. Now, in one of the cases, KP Varghese versus Income Tax Officer Ernakulam, the Supreme Court has stated that interpretation of a statute being an exercise in the ascertainment of meaning, everything which is logically relevant should be admissible in interpretation of a statute, right? Now, I would like you people to briefly reflect on this particular point in about, say, for example, 2-3 minutes. And then I want you people to give your one reflection about this whole pari materia thing and this interpretation thing in the chat box. I want everybody to respond. Okay, so all of you should respond. Okay, I'm getting the responses. Very nice. Pari material. Okay, Ritika, good. Uh, AS pari materia to essay. Good, good. That is a good application. Okay, nice. So the people who have responded, many thanks. Very good that you have responded. So it is always better when you get responses. Now, let us move further and I will take you to one by one. So you will come to know, understand it more better when we are talking. And parimateria, I will be giving you examples in between also. So let us have a look at this long title. Okay. So this is the long title. What is a long title? Long title, as you are able to see in this Companies Act, concentrate on the right hand corner of the slide. On the right hand side, there is a Companies Act written, okay, Act number 18 of 2013. So the Companies Act 2013 is basically the title of the law. Okay. Now, what is a long title? Long title follows this. So you can see there is a term which is written, an act to consolidate and amend the law relating to companies. This is the long title of the statute, or you can say legislation. There is also a short title, by the way, okay, abbreviation, or you can say nickname of the legislation. That is the Companies Act 2013. The act may be called the Companies Act 2013, and we make it further smaller, in our daily language, and we say CA2, CA13 or CA2013. So, but as per statute, the long title is an act to consolidate and amend the law relating to the companies. This is the long title. Now, long title, whether this can be used, because this is not a section, this does not provide anything, right? But whether this can be utilized for interpretation is a question. And in number of cases, it has been held, it is now settled that long title of an act is part of the act and is admissible as an aid to its construction. That is what was held in R versus Secretary of State, 1994, All England Law Reporter. If you come back to India and try to see a case in Ashwini Kumar Ghosh versus Arbinder Bose, the title of a statute was held to be an important part of the act, and it may be referred for the purpose of ascertaining its general scope and of throwing light on its construction, although it cannot override the clear meaning of the enactment. So it basically tries to focus and give you the overall perspective of the law. So the long title can always be utilized. It is not necessary that every time you will be required to go to the long title. If your section is very clear, there is no need for an aid, right? You read the section, you understand it and apply it. But in many situations, the sections are not clear. Then you go back to the long title or maybe other internal aids or external aid to find the exact meaning. I'll give you some more example. Let us talk about this Bharatiya Sakshya Adhiniyam. This is basically Indian Evidence Act now in the new form. Okay. And it has got a long title like this. It says an act to consolidate and to provide for general rules and principles of evidence for fair trial. So see, there are so many words used and everything has got a meaning. So say, for example, if there is a construction issue somewhere, court would look at it. Why this evidence law is there? To provide fair trial. If the fair trial is not being provided, they can read it to support the provision, isn't it? Similarly, an act to consolidate and provide for general rules of principles of evidence. So there may be specific rules of evidence and principles given in a different statute, isn't it? So there are many things which can be interpreted out of this particular long title. So long title gives that leverage, or you can say play of things to the courts for giving proper interpretation. Let me show you another important long title. And this is actually long. So if you see this bill, this law, this is Aprajita Women and Child West Bengal Criminal Laws Amendment Bill. I don't know whether you know the history of this particular bill. This bill came up after the RG car, rape incident. Now, there was a lot of hue and cry. You all know about that particular rape case. And after that, the government, the West Bengal government came up with this particular law. to show that they are very, very stringent on these kinds of offenses, and they have brought this. And you can see its long title. How does it go ahead? It says to amend the Bharatiya Nyaya Sanhita 2023, the Bharatiya Nagrik Suraksha Sanhita 2023, and the Protection of Child from Sexual Offences Act 2012 in their application to the state of West Bengal to enhance punishment and to continue the framework for inter alia expeditious investigation and trial of the heinous act of violence against women and children. So this law basically focuses on providing speedy justice to the women victim and children, right? So this is something which is a very, very nuanced, and you can see it is a very detailed long title. Now let us move ahead and have few more examples. Okay, so we will go and have extended understanding of our Ashwini Kumar Ghosh versus Arvind Bose. So in this case, what has happened is the case arose concerning the interpretation of a statutory provision relating to the legal profession under the Advocates Act 1926. This is a case which was decided in 1952, by the way. Okay, but now Advocates Act 1969 is there. So this Advocates Act got amended. Now there is a different law which governs the lawyers. At that point in time, this was the law which used to govern the lawyers. So here a dispute emerged between two categories of legal practitioners. So there was one category of advocates who practiced in high courts and were enrolled under the Act. And there were attorneys who were traditionally associated with the Supreme Court of Calcutta. Now you will be surprised to know there was a Supreme Court in Calcutta. Okay, so during British period, the Supreme Court used to be in Calcutta. It was not in Delhi. Now, the case required the Supreme Court to determine whether the terms of the Advocates Act 1926 permitted advocates to appear in all courts, including Calcutta High Court, or not. So, whether the long title of Advocates Act 1926 can be used as an aid for statutory interpretation in resolving legal question at hand was the question before the court. The court said an act to, this was the long title, an act to authorize advocates of the Supreme Court to practice as of right in any high court. This is what the title, long title of the Advocates Act 1926 said. So what does the long title indicate? It indicates that any advocate who is there at the Supreme Court have a right to practice at any high courts. This is what the long title says. So while interpreting the provisions, the court reasoned that the long title underscored the intention to harmonize and systematize the rights of legal practitioner, aiming to eliminate unnecessary distinction between different classes of practitioners, whether they are attorneys or advocates, it doesn't matter. So this is how the interpretation of Ashwini Kumar Ghosh and Arvind Bose was done with reference to the long title. So I hope you are clear about the long title. My suggestion would be that look at some legislations and read their long title. Most of the places you will find only one line long title, and this is how this works. Okay. Now, second aid to interpretation which you find in the statute is preamble. So after the long title, generally you will find preamble. So the preamble of the statute is like a long title, is the part of the act, and is an admissible aid to construction. Although not an enacting part, the preamble is expected to express the scope, object, and purpose of the act more comprehensively than the long title. Definitely, the preamble to the act discloses the primary intention of the legislature, but can only be brought in as an aid to construction if the language of the statute is not clear. This terminology, this line, you must be witnessing that it is there at every place. Okay. Which one? That primary intention of the legislature, if it is clear, then you don't have to go into the language detailing. You don't have to go to the aid if the section is clear, right? It cannot override the provisions of the enactment. This is something which is very clear. Let us take an example. This example is there in your course material. So it says, use of word may in section 5 of the Hindu Marriage Act. So in section 5 of the Hindu Marriage Act uses the word may. 1955, which provides a marriage may be solemnized between two Hindus. Now, the question was, in this particular case, that can a marriage between a Hindu and a Christian be solemnized under the Hindu Marriage Act. Now, since the word may was used, the lawyers made an argument that it is saying may, it is not shall. So definitely a marriage between a Christian and a Hindu female can be solemnized under Hindu Marriage Act. But the courts went to read the preamble, and they said that the preamble says an act to amend and codify the law relating to marriages among Hindus. It does not mention any other religion. That is why this particular law specifically applies only to Hindus who are Hindus, and it does not apply to other people. Now, what happens when there is a Hindu and a Christian? There is a special marriage act. So the marriage has to be solemnized as per the special marriage act. If there are Muslims, then their personal law, apply. So this is the point which has been discussed here in this particular situation. So Hardik, may and shall can be used interchangeably is not correct. You have to see may has to be used as may, shall has to be used as shall. But there are exceptional circumstances, and we will see that in exceptional interpretation. In a while, I will talk about that. Okay. Now, let us move ahead and take few more examples of preamble. So this is an interesting case law, and you can see here, this is with reference to Karnataka Contract Carriages Acquisition Act 1976. Okay. And the objective of this particular law was to provide for acquisition of contract carriages and for matters incidental and similar. So their preamble went like this. It said, whereas contract carriages and certain other categories of public service vehicles are being operated in the state in a manner highly detrimental and prejudicial to public interest, and whereas with a view to prevent such misuse and also to provide better facilities for the transport of passengers by road, and to give effect to the policy of the state towards securing that the ownership and control of the resources of the community are so distributed as best to serve the common good. Where do you find this particular line? Can anybody tell me? This is a good surprise question for you. Yes, this particular line. To give effect to the policy of the state towards securing that the ownership and control of the resources of the community are so distributed as to best serve the common good, and the operation of the economic system does not result in the concentration of wealth and means of production to common detriment. Where do you find this? Not beneficial construction. It is in Constitution. Article 39 talks about it, that the Constitution, the state's actions should be there for common good, not for common detriment. That is basically socialism under the Constitution. Okay. And whereas for the aforesaid purposes, it is considered necessary to provide for the acquisition of contract carriages and certain other categories of public service vehicles in the state and for matters incidental. So this is what is the preamble. So while interpreting the preamble, the court said it is apparent from the preamble of the Act that the primary object of the Act is acquisition of contract carriages with a view to preventing misuse and also to provide better facilities for the transport of passengers by road. So this is what courts have interpreted. So I just wanted to put across to you that preamble can also be utilized for interpreting the provisions. Okay. Now let us look at another preamble, and this is again same Aprajita Women and Child West Bengal Laws Amendment Bill. See, the preamble is here. Where is the preamble? The to amend this BNS and everything, this is basically the long title. After the long title, there is a preamble. So read the preamble, what it says. The preamble says, whereas it is expedient to amend the Bharatiya Nyaya Sanhita, the Bharatiya so-and-so and POCSO in their application to the state of West Bengal for the purposes and in the manner hereinafter appearing. Then, and whereas it is expedient to provide for constitution of special courts and allied mechanism to ensure the speedy trial of specified offences against women and children and for matters connected therewith or incidental thereto. So this is what is the preamble. In light of this preamble, if you have to interpret one provision under the law, this is one of the provision under the Aprajita Act. It says Constitution of the Aprajita Task Force. So there is a Constitution of Aprajita Task Force and it mentions different duties. So say, for example, if there is a challenge to the constitution of this Aparajita task force, court can always go back to the preamble and see what is the objective of the law. Why? It is basically to provide for special courts. It is provide for allied mechanisms to help the speedy trial or against the specified offenses against women and children. So this is the objective of reading the preamble. I hope this example clarifies your idea about usage of preamble in interpretation. Now, we all know about preamble of the Constitution of India. Constitution has now completed 75 years, and we have celebrated, just yesterday, we celebrated the 76th Republic Day. And Republic Day is celebrated to mark the enforcement of the Constitution of India. We adopted the Constitution on 26th day of November 1949, and this was considered as the law day, or it is also known as the law day. So now what the preamble says. Now let us take this particular occasion and 1 second to read the preamble, because reading the preamble again and again, it is always better, right? So let us read the preamble, what it says. It says, we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So in interpreting the constitutional provision, preamble has been considered as one of the basic texts. So the preamble is part of the Constitution. It is not considered as an extra, aid. It is part of the Constitution and enjoys the legal force. The preamble is the key to understanding the Constitution and interpreting its clauses. The preamble, together with the fundamental rights and directive principles of state policy, the most important parts of the Indian Constitution, constitute the core of the Constitution, and they are also referred to as basic feature of the Constitution in Keshavananda Bharati case versus State of Kerala. So the preamble of Constitution is different than the preamble of a normal legislature or a statute. Preamble of the Constitution is part of the Constitution. So let us take another example. For example, the Supreme Court relied on the preamble in establishing the constitutional authorities draw their strength directly from the people of India, clarifying the character of India as a socialist republic, recognizing the possibility of the nationalization of private industries in order to secure equality and justice, and granting the expression social justice, the status of a constitutional right. These references are interpretive, yet their quantity and length indicate a more substantive role of the Indian preamble in constitutional interpretation. So when you are doing a constitutional interpretation, preamble serves a very important element. Okay. Now let us move further and talk about the another important internal aid to the Constitution, in the internal aid to the statutes, and that is called heading. So what are headings? So you will see that in your statute, the the sections are arranged in a group, or maybe they are in one way. There you will see that there are headings given. And these headings have given you an example of Companies Act. So if you see Companies Act, Chapter 2, there is below that you can see there is a heading. What is that heading? This heading is referred to as incorporation of company and matters incidental thereto. So these are all things related to incorporation of a company, section 3 to 22. Similarly, in chapter 3, you will find prospectus and allotment of securities. In this, further there is a heading, part 1, which deals with public offer. Then there is another part which deals with private placement. So these sections deals with public offer. So these headings have been considered. The headings or title prefixed to the section or group of sections can be referred to in construing an act of the legislature. This has been held by the court. The headings of different portions of statute can be referred to determine the sense of any doubtful expression in a section ranged under that particular heading, right? However, they cannot control the plain meaning of the words. This is very clear, okay? So say, for example, you are reading 23 to 32 in this case. This deals with public offer. But if you want to utilize something, like say, for example, you are talking about shelf prospectus. Can there be a shelf prospectus in private placement? Can there be a red herring prospectus in private placement? You have to have a look at it, right? So this is something which you look at. So shelf prospectus here is referring to public offer. We are referring to red herring prospectus. We are referring to public offer. So this heading provides a kind of a categorization or a bucketing, you can say. So if there is a confusion with reference to that, you go back to the bucketing to try to understand what exactly it is saying. In one of the case, that is Frick India Limited versus Union of India, the Supreme Court has said that it is well settled that the headings prefixed to sections or entries cannot control the plain words of the provision. They cannot also be referred to for the purpose of construing the provisions when the words used in the provision are clear and unambiguous. Nor can they be used for cutting down the plain meaning of the words in the provision. Only in the case of ambiguity or doubt, the heading or subheading may be referred to as an aid in construing the provisions, but even in such a case, it should not be used for cutting down the wide application of the clear words used in the provisions. So very, rarely you use this heading as an interpretation, but definitely it can be used as the interpretation in interpretation of the document, right? Now, let us move ahead and talk about another important internal aid that is called marginal notes. So marginal notes are very, very interesting, area, but let us talk about marginal notes in a while. I would suggest if you can read this, the whole provision once. Give me a second, 2 minutes. Well, I think you got a very long reading of the marginal notes, right? So, what did you get from this? What is the idea which you are getting? Any inputs which you can give in the chat box? So, marginal notes are basically summaries and side notes often. So, where is the marginal notes in this? You can see there are different marginal notes. There are two marginal notes. These are the marginal notes. So these marginal notes are basically a kind of a heading of that particular section. Okay. And this is coming from Bharatiya Sakshya Adhiniyam. Okay. So you see section 13, what is the marginal note saying? It is basically facts bearing on questions whether act was accidental or incidental, intentional. Section 14, it is existence of course of business when relevant. So these are called marginal notes. So marginal notes are summaries and side notes often found at the side of a section or group of sections in an act, purporting to sum up the effect of that section or sections. They are not a part of the enactment. So as you can see here, they are not part of this particular section, but they are passed by the parliament. So, but when the act is passed, the parliament, they are inserted after the act has been so passed. Hence, they are not aid to construction. This is what is said about marginal notes. You cannot refer to them as in detail. In generally, that is what it is said, that marginal notes are of no use. But in CIT, Ahmed Bhai versus Umar Bhai, Patanjali Shastris declared marginal notes in an Indian statute as in an act of parliament cannot be referred to for the purpose of construing the statute, and the same view has been taken in many other cases. So marginal notes are of not use. Many cases show that reference to marginal notes may be permissible in exceptional cases for construing the section. Like for example, in Diwan Singh versus Rajendra Prasad or Devi, briefly, but generally marginal notes are not a good aid to construction. However, marginal notes appended to articles of constitution have been held to be part. So you can see in preamble also we saw, as well as in case of marginal notes, in reference to Constitution of India, they have a different utility. So if say for example here in admission or establishment of new states, Parliament may be law admit in union or establish new states or such terms and conditions as it thinks fit. Name and territory of the union, formation of new states and alteration of areas, boundaries or name of existing states. So these are the marginal notes in a constitution. So they can be utilized for interpretation of constitution, but not in case of any other situation. These are not summary notes exactly. You can say these are kind of a title, basically. These are all marginal notes briefly. But I will show you one interesting, notes. And this you will see. This is another marginal notes, and this is coming from again Bharatiya Sakshya Adhiniyam. You see, these are the marginal notes. In case of section 46, it is saying in civil cases, character to prove conduct imputed irrelevant. In criminal cases, previous good character relevant. In case of evidence of character or previous sexual experience, not relevant in certain cases. Previous bad character not relevant except in reply. So this is under the Evidence Act or Bharatiya Sakshya Adhiniyam. This is interesting, marginal. It is not marginal notes, but this is notes. And this is not in an act, but in a regulation by SEBI. This is SEBI prohibition of insider trading regulation. And interestingly, you see in this particular thing, they, while providing the regulation, they have provided the notes of interpretation. It is a unique legislation. You will not find at many places. As I have dealt with this particular legislation, this is a recommendation from N.K. Sodhi Committee report on insider trading regulation. Probably you as chartered accountants must be aware about insider trading regulation. Probably, I don't know whether that is part of your syllabus right now or it will be in advanced course. If you see here, in this, they have provided the notes. So they have provided how this needs to be interpreted. Okay. So say, for example, we are reading communication or procurement of unpublished price sensitive information. Now section is mentioned. After section, they provide the note. And what note says? This provision is intended to cast an obligation on all insiders who are essentially persons in possession of unpublished price sensitive data. Now see, this particular notes and everything was provided by the N.K. Sodhi committee report for the legislation to be looked at. But legislation made this as the complete regulation itself. Now, since it is made as a regulation now, this is part of the legislation now. So this notes has to be read with. So far, I have not found any interpretation as such here, but let us see how if any interpretation in future comes up. But beautifully, the N.K. Sodhi committee actually talks about the objective of these notes. And you see, read this particular objectives, it is quite interesting. It says, the committee wishes to highlight a very important recommendation that it has made and hopes that not only SEBI, but every regulator adopts this recommendation in their lawmaking role. The proposed regulations contain specific notes on each provision, setting out the legislative intent for which that provision has been formulated. These notes are meant to be an integral and operative part of the regulation and are aimed at telling society what role the regulatory system expects the provision of the regulation to perform and help in their interpretation. The committee believes that in formulating regulatory policy, the author of the legislation should take courage not to stop short of articulating what the legislation was meant to achieve and intend to mean. Supreme Court of India has observed the authors of subordinate legislation ought to articulate what they intended to legislate when writing regulations. The committee believes that this is even more necessary in case of complex specialized legislation which has quasi-criminal implications such as the proposed regulation. Now see, this is what they have said, but unfortunately, after this regulation, I don't find any regulation which has given such detailed notes. So this is quite an interesting anecdote for you people to note. I hope you enjoyed this particular part, and we'll read more on this aspect. So basically, crux of the matter is that marginal notes are generally not to be interpreted to interpret the provisions. Very, very exceptional circumstances, you can utilize the marginal notes. Am I making sense? Now let us move ahead and talk about another important internal aid to the Constitution, and that is called definitional sections or interpretation clauses. On definitional sections or interpretation clauses, it is basically, you can see here, we are talking about the object of a definition or interpretation clause is to avoid the necessity of frequent repetitions in describing all the subject matter to which the word or expression so defined is intended to apply. Basically, the purpose of a definition clause is twofold. One of the purpose is to provide key to the proper interpretation of the enactment. This is one objective. Second objective is to shorten the language of the enacting part by avoiding repetition of the same words contained in the definition part every time the legislature wants to refer to the expressions contained in the definition. So construction of definitions may be understood under the following headings. Okay. Restrictive and extensive definitions, ambiguous definitions, and definitions subject to contrary context. Now let us look at each one of them one by one. So restrictive and extensive definitions. Legislature basically has a power to define a word even artificially. They can define that, and they have done it many times. For example, Section 8 of the IPC defines gender, and it says the pronoun he and its derivatives are used of any person, whether male or female. So they have said he means she means he. This is what they have said. Okay. Now, similar kind of a definition you can see in Bharatiya Nyaya Samhita also, and they have elaborated further to include transgender. Okay. And he said gender, the pronoun he and its derivatives are used for any person, whether male, female, or transgender. And they have further elaborated in explanation what the transgender means. Here you can see there is a reference to the Transgender Act also. So the definition of a word in definition section may either be restrictive of its ordinary meaning or it may be extensive of the same. Okay. So this is the idea. It is there in the General Clauses Act. Now, let us move ahead and try to understand the word when there are three types of word which can be utilized for defining a definition. Okay. One of them is to utilize the word mean. So when a word is defined to mean such and such, the definition is prima facie restrictive and exhaustive. We must restrict the meaning of the word to that given in a definition section. However, when the word defined is using the word include such and such, the definition is prima facie extensive. Here, the word defined is not restricted to the meaning assigned to it, but has an extensive meaning, which also includes the meaning assigned to it in the definition section. We may also find a word being defined as means and includes. In such a situation, the definition would be exhaustive. On the other hand, if the word is defined to apply and to include, the definition is understood to be as extensive. Let us take some examples. One of the examples here is Section 2M of the Consumer Protection Act. It is an inclusive definition, as you are able to see. What is the inclusive definition saying? It is saying that person. It is an inclusive definition of person. It has been held to include company, although it is not specifically named therein. A definition section may be worded as is deemed to include, which again is an inclusive or extensive definition. As such, a word are used to bring in by a legal fiction something within the word defined, which according to its ordinary meaning is not included within it. Now, in Constitution, there is a provision and it has been interpreted, Section 236, in state of Maharashtra versus Labor Practitioner, and it said the inclusive definition of district judge in section Article 236A. As you can see here, district judge is defined to include additional district judge, joint district judge, assistant district judge, but it nowhere mentions labor court or industrial court. So the court here said that it is an inclusive definition and it will include all hierarchy of a specialized civil courts also into it, which includes labor courts, industrial courts, and nowadays we are having commercial courts. So these courts will also be included here in the definition. This is what State of Maharashtra versus Labor Practitioner Association said. This is the purport of the definitions part of it. There may be also ambiguous definitions many a times, okay? And it is normally presumed that legislature will be specific and precise in defining the definitions. But many a times it happens that there is a requirement of interpreting the definition itself. Ideally speaking, definition is meant for curing the issue. But many a times the situation arises that definition requires an interpretation. And in Section 200 of the Industrial Disputes Act, there was a definition of retrenchment. Okay, so here it said retrenchment means the termination by the employer of the service of a workman for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action, but does not include the following, that is voluntary retirement of a workman, retirement of workmen on reaching the age of superannuation, if contract. So these are the conditions which are given for not considering the person to be under retrenchment. So here the termination of service in this particular case of a seasoned worker after the work was over was not considered to be an retrenchment as per the Industrial Disputes Act. This was the Anil Bapu Rao's case. But the termination of employment of a daily wager who is engaged in a project on completion of the project will amount to retrenchment if the worker has not been told when employed that his employment will end on completion of the project. So this is what is the interpretation given in case of ambiguous decisions. So when you are employing a person, at that point in time, you should have told him that it is the work which is only for 6 months and your work will end in 6 months. If you have not done so, and then abruptly end his employment, that will amount to retrenchment. This is what was the interpretation given in SM Nilajkar Telecom District Manager Karnataka's case in 2003. So I hope you understood what is the definition of ambiguous definitions. Now, there are definitions which are subject to the contrary context. And here, when a word has been defined in the interpretation clause, prima facie, the definition governs whenever that word is used in the body of the statute. So wherever there is a word which is used in the body of the statute will have to be taken into consideration in the same meaning. You cannot change the meaning in the statute. This is one example of the case. So this is Vanguard Fire General Insurance versus Madras, Fraser and Boss another. Here, Justice P.B. Gajendra Gadkar was giving this particular decision. It was a 5-judge bench again, 4-judge bench case. And here, if you will see, read it from the definition, third line on the left side. It is saying, it is well settled that all statutory definitions or abbreviations must be read subject to the qualification variously expressed in the definition clauses, which created them, and it may be that even where the definition is exhaustive, inasmuch as the word defined is said to mean a certain thing, it is possible for the word to have a somewhat different meaning in different sections of the Act, depending upon the subject or the context. That is why all definitions in statutes generally begin with the qualifying words similar to the words used in present case, namely, unless there is anything repugnant to the subject or context. So you can see definitions are not always exhaustive. If there is something context requires a different idea, then that has to be in a different way. It has to be interpreted. In this case, there was an issue on the definition of insurer. So they said, therefore, in finding out the meaning of the word insurer in various sections of the Act, the meaning of the ordinarily given to it that given in the definition clause, but this is not inflexible. And there may be sections in the Act where the meaning may have to be departed from on account of the subject or context in which the word has been used. And that will be giving effect to the opening sentence of the definition section, namely, unless there is anything repugnant or subject to context. In view of this qualification, the court has not only to look at the words, but also look at the context, the co-allocation and object of such words relating to such matters, and interpret the meaning intended to be conveyed by the use of words under these circumstances. Therefore, though ordinarily the word insurer as used in the Act would mean a person or body corporate actually carrying on the business of insurance, it may be that in certain sections, the word may have somewhat different meaning. A perusal of the few sections of the Act will illustrate this and immediately show that word insurer has been used in some sections to mean not merely a person actually carrying on the business of insurance, but also a person who intends to carry on the business of insurance, but has not actually started it, and also a person who was carrying on the business of insurance, but has ceased to do so. So see, it has included insurance in present, insurer in past, and insurer in future. So this is what the context basically means. So this is a very interesting, understanding of the topic on subject to the contrary to the context. I hope this clarifies your idea about the definitional clause and how definitional clause is being utilized. Now we will move further and talk about another important, element, that is illustrations. So illustrations appended to a section basically form the part of the statute and are of relevance and value in construction of the text of the section, and they should not readily be rejected as repugnant to the section. Generally, they are considered as part of the section. However, they cannot have the effect of modifying the language of the section, and they cannot either curtail or expand the ambit of the section, which alone forms the enactment. Here I am giving you an example from Bharatiya Saksha Adhiniyam 2023. So you can see here, you can see many things now in this particular thing. Okay, you are able to see the marginal notes on the left hand side. You are able to see the heading, that is closely connected facts. You are able to see the section, that is section 4, and section is in 3 lines.
and below that there is an illustration. So illustration is basically an example. So I would give you some time to read these examples. Please read them one by one. Yes. Okay. So I will again read it. A. A is accused of the murder of B by beating him. This is the illustration. Okay. Whatever was said or done by A or B or by the bystanders at the beating or so shortly before or after it as to form part of the transaction is a relevant fact. So this is how you define the closely connected facts. Okay. So during the prosecution of a murder, you must have seen a number of movies are now coming on murder trials. Okay. So you must have seen the prosecution or the investigator looks at everything. Okay. What has happened before, what has happened afterwards. All these things are relevant facts in proving that particular murder. So this is what basically this illustration is trying to explain. Similarly, let us see the D1. It says the question is whether certain goods ordered from B were delivered to A. The goods were delivered to several intermediate persons successively. Each delivery is a relevant fact. So you must be receiving couriers, right? So in the courier, nowadays there is a tracking service. So you must be seeing your courier has reached from Chennai to airport, Chennai airport. From there, it has gone into the flight from there. So each of these transactions are relevant facts, whether it actually boarded the plane or not. So these are the things which are mentioned in the Evidence Act. Evidence law is quite an interesting law. Well, I hope this clarifies your point on illustration. We'll look at one more illustration, which is of relevance for you, is on Contract Act. So you are seeing this is a illustration for communications. The section talks about communication when communication is complete. So here you see illustration says A proposes by letter to sell a house to B at a certain price. The communication of the proposal is complete when B receives the letter. This is what first illustration. Okay. When the communication is complete, when B receives the letter, like this. Okay. These are illustrations. There is another example of illustration, and this is the Juma Masjid case versus Koda Devaya, Kodi Maniandra Devaya. Now, this illustration appended to this was with the section 43 of the Transfer of Property Act, and we have deferred consideration thereof to the last. So this is the illustration. A Hindu who is separated from his father B sells to C 3 fields X, Y, Z, representing that A is authorized to transfer the same of these fields. Z does not belong to A, it having been retained by B on the partition. But on B's dying, A as his heir obtains Z. C, not having rescinded the contract of sale, may require A to deliver Z to him. Now this illustration itself is complicated, A, B, C, D, A, Z. But here in this case, in this illustration, when A sold the field Z to C, he had only a spes successionis, but he, having subsequently inherited it, became entitled to it. This would appear to conclude the question against the appellant. But it is argued that the illustration is repugnant to the section and must be rejected. So here court said, if the language of the section clearly excluded from its purview transfers in which the transferor had only such interest as is specified in section 6A, then it would be undoubtedly not be legitimate to use the illustration to enlarge it. But far from being restricted in its scope, as contended by the appellant, the section is, in our view, general in its terms and of sufficient amplitude to take in the class of transfers now in question. It's not to be readily assumed that an illustration to the section is repugnant to it and rejected. So this is Generally, whenever there will be illustration to a statute or a section, that will not be rejected by saying that it is repugnant. Generally, it will be tried to construed to explain the meaning of the section. This is what it has been told here. So in this particular case, reference may in this connection may be made. Court refer to this case, very landmark case on illustrations, Mahmoud Shedol Arfin. And here it said the court referred to it, and it said it is the duty of the court to accept if that can be done. The illustrations given as being both of relevance and value in the construction of the text. The illustrations should in no case be rejected because they do not square with ideas possibly derived from an other system of jurisprudence. As to the law with which they are, the sections deal, and it would require a very special case to warrant their rejection on the ground of their assumed repugnancy to the sections themselves. It would be very last resort of the construction to make any such assumption. The great usefulness of the illustrations, which have, although not part of the sections, been expressly furnished by the legislature as helpful in the working and application of the statute, should not be thus impaired. If the language of the section clearly excludes from its purview certain matters, it would not be legitimate to use the illustrations to the section to enlarge it. It is not to be readily assumed that an illustration to a section is repugnant to it and rejected. This is what was held in Vickers versus Evans. So as you can see, the illustrations have to be looked at as the provision which can be helpful for interpretation. So friends, I think we are at 7:16 now already. So I'll give you a break and I think I can give you a break of another 15 minutes. So let us meet at maybe you can take 7:35. I think that will be better. 7:35. We meet again at 7:35. There is a break till 7:35. Join sharp at 7:35 again, and people who are here, if you want to be here, you will be here.
put it in chat box. I will be happy to answer them. Chartered accountants, Ritika, cannot represent other people at the courts because it is something which has been meant for the lawyers. You have to be a lawyer before you appear before any courts. However, there are certain forums where CAs can represent. For example, consumer protection forums. There, any person can appear on behalf of anyone. And I think some regulatory bodies also accept the representation. In NCLT, I think they represent the exception. Okay. I'm a teacher right now. I was a lawyer. I worked as a lawyer sometime. Yeah. Okay, so far we have dealt with the internal aids to construction, and we talked about some important terminologies, like we discussed long title, we talked about headings, we saw the value of a preamble, we have seen illustrations, and now we are moving ahead and talking about few more. Okay. Now, let us move further and talk about proviso. Now, so the proviso basically is something which is there in a statute, and objective of the, basically you can see here in this Bharatiya Sakshi Adhiniyam, this is the proviso, provided that this is the proviso, and it has got two provisions. So there are second proviso is provided further that. So these are the provisions. So as you will read the section, it is on oral evidence. Of oral evidence is the heading. Proof of facts by oral evidence to be direct. These are the marginal notes. And section is in case of oral evidence. You see the oral evidence is mentioned there. And oral evidence shall in all cases, whatever be direct, if it refers to a fact which could be seen, a fact which could be heard, a fact which could be perceived by any other senses, an opinion or the grounds on which the opinion is held, it must be evidence of the person who holds that opinion on those grounds, right? Provided that the opinions of experts expressed in any treatise commonly offered for sale and the grounds on which such opinions are held may be proved by production of such treatise if the author is dead or cannot be found. This is one of the provisions. Second provision is said, provided further that if oral evidence refers to existence or conditions of material thing other than a document, the court may, if it thinks fit, require the production of such material thing or it for its inspection. Let's say, for example, someone is saying about metal, then that can be brought further. Say, for example, they are saying that this is the murder weapon. That weapon can be brought before the court for inspection. This is the point on oral evidence. So normally, the function of a proviso is to accept something out of the enactment or to qualify something stated in the enactment
which would be within its purview if the proviso were not there. Okay. Now, usually a proviso is embedded in the main body of the section and becomes so integral part of it. Provisos are so included, begin with the words provided for, as you can see, provided that. The effect of proviso is to qualify the preceding enactment, which is expressed in terms which are too general. As a general rule, a proviso is added to an enactment basically to qualify or create an exception to what is in the enactment. Ordinarily, a proviso is not interpreted as stating a general rule. So this is what is about the proviso. So basically, if you will see section 55, which has got proviso here in this case of an example, there are 4 situations where it says oral evidence shall in all case whatever be directed if it refers to the following 4. However, there are 2 situations which are mentioned in proviso wherein oral evidence will not be accepted. There is a requirement of bringing the material in one case, and in another case, you see they are requiring for bringing in that treatise if the author of the treatise is dead and cannot be found, or has become incapable of giving evidence, or cannot be called as a witness without an amount of delay or expense which court regards as unreasonable, right? This is the requirement. Now, exception clauses, there are 2 other types of clauses also here. One is called exception clauses. So exception clauses are intended to restrain the enacting clause to particular cases. Savings clause, on the other hand, is used to preserve from destruction certain rights, remedies, or privileges already existing. It is a cardinal rule of interpretation that a proviso or exception to a particular provision of a statute only embraces the field which is covered by the main provision. It carves out an exception to the main provision to which it has been enacted as a proviso and to no other. This has been held in the case of Ram Narayan Sons versus Assistant Commissioner. Now, there is also a distinction between proviso, exception, and saving clause. So, exception is intended to restrain the enacting clause to particular cases. Proviso is used to remove special cases from general enactment and provide for them specifically, whereas saving clause is used to preserve from destruction certain rights, remedies, or privileges already existing. Let us take some examples of them. So, in case of a proviso, it limits or qualifies the main provision, as we discussed. It operates within the general rule, creates a condition or limitation. Example, let us look at it. Section 6 of the Transfer of Property Act. So, property of any kind may be transferred except as otherwise provided by this act or by any other law for the time being in force, provided that nothing in this section shall affect the transfer of the property by an unmarried Hindu governed by the Hindu Succession Act. Here, the proviso limits the applicability of the general rule by creating a specific exception for transfers under the Hindu Succession Act. Exception removes a particular case from main provision, excludes a case entirely from the general rule, and makes the excluded case inapplicable. Let us take an example, section 300 of the Indian Penal Code, which is defines murder. Now this has been changed. Except in the cases hereinafter, accepted culpable homicide is murder. Okay. The exceptions, that is grave and sudden provocation, remove these situations from being classified as murder under the law. Saving clause preserves the rights of the repealed law and ensures legal continuity. So section 6 of the General Clauses Act, this we have already discussed in our General Clauses Act lectures. So this saving clause ensures that previously existing rights and liabilities are unaffected by the repeal. So this is the difference between these 3 things, proviso, exception, and saving clause. Now, culpable homicide basically means murder. Okay. Now, intentional, culpable means intentional. Now, it comes to the explanation. Another internal aid to the construction is explanation. So you can see here there is a heading of documentary evidence. And in that, in case of primary evidence, there is a explanation. There are 3 explanations provided to this. So explanation is at times appended to a section to explain the meaning of certain words or phrases. used in the section or of the purport of the section. An explanation may be added to include something within that section or to exclude something from it. So it serves two purposes. Either it can add something to the definition or it can exclude certain things from the definition. So these two things you are able to see. What are they? The first one is, can you type them? The red ones, what are they? Yes. Marginal notes, yes, on the left, on the top. Heading, yes. Okay. Now let us move further and talk about the explanation. So in your course material, this example is given, that is Sundaram Pillai versus Pattabhiram. So Fajal Ali Justice basically mentioned the following objectives of an explanation. He said, explain the meaning and intendment of the act itself, clarify any obscurity and vagueness, if any, in the main enactment to make it consistent with the object, provide an additional support to the object of the act to make it meaningful and purposeful, fill up the gap which is relevant for the purpose of the explanation to suppress the mischief and advance the object of the act, cannot take away a statutory right. So this is the nature of explanation. Now, I hope the explanation is clear. As you can see here, it is there to explain. I remember one of the famous explanations in the Competition Act, because that is the area which I practiced most. So in Competition Act, Section 4 of the Competition Act defines dominance, and it is defined in explanation. So, and it borrows the definition from the European Union law. One of the important case, that is, I think, banana case, that is where they have discussed with the definition of dominance. Now, towards the end of a statute, you will find schedules. As you can see here in this particular slide, Schedule 1, Schedule 2 under the Companies Act. These provide for memorandum of association, article of association, different formats. And as well as it talks about useful lives to compute depreciation, part A, B. So these are the schedules. You can see Schedule 1 in a detailed way also here. So the schedules form part of an act. Therefore, they must be read together with the act for all purposes of construction. However, the expressions in the schedule cannot control or prevail over the expression in the enactment. If there appears to be any inconsistency between the schedule and the enactment will always prevail. Okay. So say, for example, here you are mentioning clause number 1, name of the company is so-and-so limited or private limited. So you cannot utilize this particular line from the schedule to interpret Section 4 of the Companies Act in a different way. So this is what the last point here mentions in the slide. So schedules are also part of the statute and they may be utilized for interpretation of the act. Now, this is something which is not part of your syllabus. It is not there mentioned, that is punctuations. However, punctuations are very, very important, thing for interpretation. If you look at the British law, punctuations have not been accepted as, much of a value, but later on, it has been considered as important. So punctuation is important in interpreting statutes because it can help clarify the meaning of a statute and resolve ambiguities. So punctuation marks are different, like for example, comma, semicolon, colon, dashes, and they identify the structure of a statute. So in one of the cases, the court said that it is a crucious paradox that judges whose entire reading is punctuated should, in carefully punctuated judgments, consider themselves obliged to proclaim that the punctuation in carefully punctuated statutes is no part of the law. This was quite an interesting, word play. While older dicta suggests that the punctuation should not be regarded as a decisive of meaning, this does not represent the modern view. All the same, the judge
may in some cases be compelled to correct errors in punctuation, a course which the courts are prepared to adopt more readily than amendment of the working of a statute. So basically, the older view in English courts is punctuation has not to be taken into consideration for interpretation, but subsequently, in modern days, punctuations are definitely looked at for interpreting the cases. Like in case of Ashwini Kumar versus Arvinder Bose, which we saw about the advocate's case recently, there also the punctuation was, interpreted to mean certain thing. So punctuations are part of the statute. I gave you one example you would recollect under the General Clauses Act. We discussed that for want of a comma, millions were lost, right? So when you are interpreting the contract, particularly, the punctuations play a very, very important role. Now, again, we repeat this because this is the part of your course material. So you can see statute must be read as a whole in its context. This is the rule, okay? Fourth rule, if you, second rule, if you will recollect which 4 rules which we discussed. It is the elementary principle that construction of a statute is to be made of all its parts taken together and not of one part only. The deed must be read as a whole in order to ascertain the true meaning of these several clauses, and the words of each clause should be so interpreted as to bring them into harmony with other provisions. If that interpretation does no violence to the meaning of which they are naturally susceptible, and the same approach would apply to the equal force with regard to acts and rules passed by the legislature. So if you see the example 14, if one section of the act requires notice should be given, then a verbal notice would generally be sufficient. But if another section provides that notice should be served on the person or left with him or in particular manner or place, then it would obviously indicate that the written notice was intended. So you have to see the statute in a whole context. Now let us look at the external aids to interpretation. So what is the bottom line? Bottom line is that the external aid has to be looked at when you don't find help with the internal aids. Okay, so then you look at the external aids. So when internal aids are not adequate, court has to take recourse to external aids. External aids are very useful tools for the interpretation of construction of statutory provisions. As opposed to internal aids to construction, there are certain aids which are external to the statute. Which are they? Historical setting, consolidating statutes and previous law, usage, earlier and later acts and analogous act, dictionary definitions, use of foreign decisions. These are the external aids. We will look at these external aids one by one. First one is historical settings. So by now you would have witnessed that every legislation has a history. Okay, there is an objective behind it, why that particular law came up. There may be thousands of stories behind it. Like for example, this Aparajita Act, right? There is a story. This whole RG car rape case is the story behind that law. Similarly, if you will see the criminal law amendments, which was made on the basis of Justice Verma Commission report, was because of the Nirbhaya rape case in Delhi. So there was the whole criminal law got changed because of that particular case. Similarly, you will see there is a decision of Vishaka versus State of Rajasthan, that is, sexual harassment of women at workplaces. For prohibiting that, the legislation emerged from that particular case. Similarly, you will see there are many other cases, like for example, women's right to serve in military forces. There are I think Punita Rani case. So like this, these are some of the cases which are where some of the legislation which are emerging from some stories. So historical settings means a lot while interpreting. So the history of an external circumstance which led to enactment in question is of much significance in construing any enactment. We have for this purpose to take help from all those external and historical facts which are necessary in understanding and comprehension of the subject matter and scope and object of the enactment. Nowadays, if you will see the decisions of the Supreme Court, they look at historical settings, even if it is not required. They put the background of it. And these backgrounds are helpful in understanding the nature of the law, why that particular law has come up. So history in general and parliamentary history in particular, ancient statutes, contemporary or other authentic works and writings are relevant in interpreting and construing an act. Like say, for example, Indic knowledge, the Mimamsa principle. These are the things which have been used by courts in interpreting the law. We have also to consider whether the statute in question was intended to alter the law or leave it where it stood before. So historical settings means a lot. Then comes consolidating statutes and previous laws. So a consolidating statute brings together the provisions of several earlier statutes on the same subject into one comprehensive legislative document. When interpreting such statutes, courts may look at the structure and language used in the consolidating statute. They may refer to the earlier enactments to clarify ambiguities or interpret technical words or phrases. They may determine whether the consolidating statute seeks only to restate the existing law or introduce any substantive changes. That has to be looked at it. Like say, for example, I can give you Bharatiya Nyaya Sanhita. That is again a consolidating statute and amending statute, which changes the Indian Penal Code. So whether it brings the new philosophy? Yes, on certain aspects, it has brought new philosophies. Like, for example, sentencing, it has brought community punishment. Okay. It has community service as a punishment. It has, brought electronic evidence, utility of electronic evidence. That is something which it has brought in a very big way. So these are the changes which has been brought in that particular legislation. So the Companies Act 2013, India, this is an example, consolidates and replaced earlier several laws, including Companies Act of 1956. So while interpreting 2013 Act, provision of 1956 Act, its judicial decision interpretation will be a important fact. And similarly, for example, Section 212 of the 2013 Act regarding the Serious Fraud Investigation Office incorporates elements previously scattered across older laws, allows courts to draw parallels and distinctions. Now, previous laws, judicial interpretation often involves examining earlier laws to resolve ambiguities in the current statute or understand the historical evolution of the provisions. Like, for example, in General Clauses Act is frequently referred to for interpreting terms in statutes that succeed earlier laws. For example, if statute does not explicitly define a term, court look at how the term was defined and applied in previous legislation, right? For example, one of the cases, Bengal immunity versus state of Bihar, where Supreme Court referred to pre-constitutional tax laws and earlier statutes to interpret the term sale of goods under the Constitution. Next is usage. So usage is also sometimes taken into consideration in construing an act. So the acts done under a statute provide quite often the key to statute itself. It is well known that where the meaning of the language in a statute is doubtful, usage, how that language has been interpreted and acted upon over a long period may determine its true meaning. So generally, you look at the precedents. So first thing what you will do is you will read the statute. If you are able to understand it, well and fine. Then you will look at the different aids, internal aids. If internal aids doesn't support you, we'll go to the external aids. If external aid doesn't support you, one of the external aids is usage. So you will look for the different decisions in which or precedents in which this particular provision has been interpreted. And you will try to see what meaning has been ascribed to a particular word. So it has been emphasized that when a legislative measure of doubtful meaning has for several years received an interpretation which has generally been acted upon by the public, the courts should be very unwilling to change that interpretation. So many a times things get established by way of a usage, or by using that particular term for several days, years, you use them. Then let us take an example. The income tax of India includes several terms that may be subject to interpretation, such as income or capital asset. So in the case of CIT versus Taj Mahal Hotel, the Supreme Court of India dealt with the interpretation of the term plant under the Income Tax Act. The question arose whether items like furniture and fitting in a hotel qualified as plant. Judicial reasoning given here was the court relied on the usage in the hospitality industry, where furniture and fittings were recognized as integral to the operation of a hotel. Based on this understanding, the court held that such items fell within the meaning of the plant, which could qualify for depreciation under the Act. This shows how courts use established practice and industry-specific meaning to
resolve statutory ambiguities, right? So just reflect upon this
This is the case, as you can see, and these interpretations are quite interesting. Okay, I remember one interpretation on this, and particularly these interpretations will bother you in taxation matters. And when you people will practice most of the times for CAs, the taxation and GST, these are the areas in which you will be, caught up in interpretation of the terms and words. I remember in one of the decisions, I wrote a paper long back on the question whether bubblegum is a mithai, right? So there was quite an interesting situation. And right now you must be hearing the debates about sugar caramel and all these memes are going on, right? So interpretation of these terms and words are very, very important. And particularly in taxation matters, these are important because tax slab changes if you interpret the term in a particular way, right? And most of the times, the people will be trying to, manage their tax by interpreting those terms or not bringing them into that particular category. So this is how these interpretations of or play between the law and their violators, or you can say acceptors, keeps going. Now let me move further and talk about earlier, later acts and analogous acts. So there are many legislations, so the general principle is that where there are different statutes in pari materia, we have discussed what is pari materia. In analogous case, though made at different times or even expired and not referring to each other, they shall be taken and constitute together as one system and as explanatory of each other. Now, if two acts are to be read together, then every part of each act has to be construed as if contained in one composite act. But if there is some clear discrepancy, then such a discrepancy may render it necessary to hold the later act in point of time had modified the earlier one. So generally, the subsequent act has got more valuation than the earlier act. So if there is an inconsistent provision between two, say for example, 1956 Act, Companies Act and 2013 Act. So 2013 Act will always have a valuation. But if 2013 Act has some provision which has not been given a very big clarity here, then you can refer to the 1956 Act also to understand what that particular thing would have meant. Now, where the later of the two acts provided that the earlier act should, so far as consistent, be construed as one with it, then the enactment in the later statute that nothing therein should include debentures was held to exclude debentures from the earlier statute as well. Now, where a single act section of one act, say, Act A is incorporated into the statute, say Act B, it must be read in the sense which is, born in original act from which it is taken. Consequently, it would be legitimate to refer to all the rest of the Act A to ascertain what the section means, though one section alone is incorporated in the new act. So you can always make a reference to the earlier act if the old act has been utilized to formulate the new act, or there is a change which has been brought up. Like say, for example, I can give you example of Companies Act. So Companies Act 2013, it brings forward many provision as it is from 1956 Act. So you read both these laws in pari materia. Similarly, now you are having this been in Bharatiya Nyaya Sanhita in place of Indian Penal Code. So you are trying to also go back and see what Indian Penal Code has said on these provisions and read them, right? So this is how you go ahead and interpret it. Suppose the earlier bylaw limited the appointment of a chairman of an organization to a person possessed of certain qualification, and the later bylaw authorizes the election of any person to be the chairman of organization. In such a case, the later bylaw would be so construed as to harmonize and not to conflict with the earlier bylaw. The expression any person used in the later bylaw would be understood to mean only any eligible person who has the requisite qualifications as provided in the earlier bylaw. I hope this clarifies your position. Now, earlier act may explain the later act. Earlier act may also explain the later act. Not only may the later act be construed in the light of the earlier act, but the later act sometimes furnishes a legislative interpretation of the earlier one also, if it is pari materia and if, but only if, the provisions of the earlier act are ambiguous. Where the later statute contained a negative provision, but the later only merely omits the negative provision, this cannot by itself have the reason of substantive affirmation. In such a situation, it would be necessary to see how the law would have stood without the original provision and the terms in which the repealed sections are reenacted. So you link these particular legislation and try to make sense out of the earlier laws. But again, I will draw the bottom line. If the section is very, very clear, if the context is very clear, all these things are not required. Okay. So many a times you also refer to the repealed act. So where a part of the act has been repealed, it loses its operative force. Nevertheless, such a repealed part of the act may be still taken into account for constituting an unrepealed part of the act. This is so because it is part of the history of the new act. Now let us come down to dictionaries. Now you all know definitions are provided in the definition clause. But many a times there are situations which arises where you want to understand the meaning of a word because it has not been defined. So you look at dictionaries. For your information, there are different types of dictionaries. We are talking about General Oxford Dictionary and there are law dictionary also. So there is a Black's Law Dictionary. There are different other dictionaries also. Now these dictionaries may be, trying to read the provision and trying to understand, legal dictionaries provide legal definitions to the terms which have been interpreted in different cases. So if you see, first we have to refer to the act in question to find out if any particular word or expression is defined in it. Where we find that a word is not defined in the act itself, we may refer to dictionaries to find out the general sense in which that word is commonly understood. However, in selecting one out of several meanings of a word, we must always take into consideration the context in which it is used in the act. It is the fundamental rule that the meanings of words and expressions used in an act must take their color from the context in which they appear. Further, judicial decisions laying down the meaning of words in construing statutes in pari materia will have greater weight than the meaning furnished by dictionaries. However, for technical terms, reference may be made to technical dictionaries, right? So say, for example, you are talking about engineering terms, you will refer to the engineering dictionary. Or if you are referring to any other kind of a term like that, you will be referring those kind of dictionaries, right? This is the terminology which we are talking about. Now, use of foreign decisions. Now, foreign decisions of countries following the same system of jurisprudence as ours and given on laws similar to ours can be legitimately used for construing our own acts. Examples. There are few examples of foreign decisions. First one is Keshavananda Bharti versus State of Kerala, 1973. So here the Indian Supreme Court referred to judgments from the United States, the United Kingdom, and Australia while articulating the basic structure doctrine of the Indian Constitution. The doctrine drew inspiration from foreign cases but was tailored to India's unique constitutional framework. Here you can see they have referred to the basic structure doctrine and they have referred to the different decisions of different courts. So foreign decisions are also utilized by Indian courts. There is another example is Vishakha versus State of Rajasthan. So this was a case in which, as I told you, I gave you an example. This was for a case where interpretation was done on gender rights and sexual harassment of women at workplace. And Supreme Court referred to CEDAW. CEDAW is a convention that is an international convention on elimination of all forms of discrimination against women and foreign precedents to craft binding guidelines in the absence of domestic law. Similarly, I recollect, National Company Law Tribunal referring to Singapore decision. Similarly, in many of the insolvency matters, the court has referred to the foreign decisions and they have given the interpretation. However, there is a principle of usage of foreign decisions. So foreign decisions are persuasive and they are not binding. So foreign decisions are treated as persuasive authority. They are not binding precedents. The binding precedent basically refers to Article 142 of the Constitution of India. Constitution of India, all High Court decision and Supreme Court decisions are binding on the lower courts. So foreign decisions are, not binding; they are persuasive. You also have to see they have a context sensitivity. So court must assess whether the foreign decisions is contextually appropriate to domestic legal frameworks or not, and subordinate to domestic law. The domestic legislation, judicial precedent, and constitutional provisions take precedence over foreign interpretations, and foreign decisions, when prudently applied, enrich domestic jurisprudence and ensure alignment with global legal developments while preserving the integrity of the domestic law. So this is the utility of foreign decisions in ultimately interpreting the laws. This completes our external aids to the construction. Any question you people have till this point, I will be happy to answer them. Then we will move ahead with rules of interpretation and construction of deeds. This is very brief, 2 slides, and then we will complete this. Yeah. Any questions you have, you can ask me. Okay, the NCLT and courts. NCLT is also a kind of a court only, but it is a specialized tribunal. Okay. Cardinal rule is referred to as literal rule. So cardinal rule means the primary rule, the basic rule. Yeah, excuse me, my battery is running low. I'm just putting the charger. In the meantime, you can put your questions in the chat box. Okay, so in terms of examination, you have to see how much words you can answer it, and accordingly you should prepare the concept in those words. You don't have to prepare it very, very elaborate. So accordingly prepare it. I think anything which is there and you want to explain, a brief explanation and then one example will suffice. I think that is how you should prepare. Okay, so proviso and exceptions, these are the 3 different terms which are used. If you see there, I will come to that particular slide specifically and explain you again. Let me complete this thereafter. Okay, so let us complete this presentation and then I will take further questions. Okay. The last part of your module is rules of interpretation, construction of deeds and documents. So first, let us understand what is a deed and a document. So you will see there are different deeds and documents which are there made. So there may be share purchase agreement, there may be sale deed, there may be conveyance deed. These are all different documents and deeds. By the way, we all keep signing the documents without reading them many a times.
Like say, for example, there is an insurance contract. That itself is a document. There is a WhatsApp when you accept. There is an agreement. These are all called click wrap agreements. So you click on a button of a click, you accept the whole agreement, and then you are bound by that particular agreement. So interpretational rules of the deeds and documents, the first and foremost point that has to be borne in mind is that one has to find out what a reasonable man. So there is always a reasonable man standard in interpretation of deeds and documents, who has taken care to inform himself of the surrounding circumstances of a deed or document and of its scope and indentments, would understand by the words used in the deed or that particular document. So the standard of interpretation of a deed and a document is a common man. The principle of construction in case of a document and a deed as of a statute does not differ so much except in some minor details. Okay. Now, if you read a deed must be read as a whole in order to ascertain the true meaning of its several clauses. And the words of each clause should be so interpreted as to bring them in harmony with other provisions if that interpretation does no violence to the meaning of which they are naturally susceptible. This is what Lord Watson has to say. In all cases, endeavor shall be made to find out how a reasonable and well-informed person would understand by the words used in the deed or the document. So you see, a general common parlance interpretation is given to the deeds and documents. The golden rule of construction is to ascertain the intention of the parties to the instrument after considering all the words in the ordinary natural sense. So this intention of the parties is a very important element in case of contracts and deeds and documents. This is also referred to as principle of consensus ad idem. So to ascertain this intention, the court has to consider the relevant portion of the document as a whole, and also to take into account the circumstances under which the particular words were used. Very often the statutes, the status and the training of the parties using the words have to be taken into consideration. So if at one end there is a parda nashi lady and the second end you are contracting or purchasing a house, then that will be taken into a different interpretation. If there is a person who has put his thumb impression on a document, would be taken into consideration in a different way than a well-educated person signing a document. So these considerations also play a role in interpretation and construction of deeds and documents. Particularly, you will see interpretation of a will. You try to see that how this has happened. You also look at the circumstances. Like say, for example, somebody is there and who has these things you must be seeing in movies, where the person has written a will in the favor of their servant and nobody else in their family. Now, this raises suspicion, right? So this is how the courts probate the will, and they look at the interpretation of that particular provision. So it has to be borne in mind that very many words are used in more than one sense, and that sense differs in different circumstances. Again, even where a particular word has to be trained conveyancer a clear and definite significance, and one can be sure about the sense in which such conveyancer would use it, it may not be reasonable and proper to give the same strict interpretation of the word when used by one who is not so eloquently skilled. This is what exactly I was telling you, that a CA preparing a document and a lawyer preparing a document and an uneducated person preparing a document, these are three different things. Okay. And that has to be looked at it in a different way. So it is expedient to construe the terms of one deed by reference to the terms of another. It is an elementary rule of construction that same word cannot have two different meanings in the same document unless the context compels the adoption of such a course. The document must be read as a whole and the intention deduced therefrom as to what actually the parties wanted or intended to agree. It may also happen that there is a conflict between two or more clauses of the same document, and then in that situation, an effort has to be made to resolve the conflict by interpreting the clauses so that all the clauses are given effect. You remember now the four rules which we talked about it? So that four rules apply to construction of deeds also very, very clearly. Okay. Intention of the legislature has to be replaced by intention of the parties. That's it. Rest, the three rules apply similarly.
Similar, if one part of the document is in conflict with another part, an attempt should always be made to read the two parts of the document harmoniously, if that is possible. If not possible, you sever the part. You take the first part, second part, you leave it. That is how you read the documents. These are some of the references which I utilize for preparing the presentations. And if you are interested in reading more about interpretation, kindly you can go through these particular books. They are very interesting. I have this Justice G.P. Singh's Principle of Statutory Interpretation. I recommend this book. It is a very nice book which explains everything in detail. So that's it. This is what was there from my side. I will now take up questions, and I will take you specifically to the questions where you have asked me questions. Let me bring the slide there and then discuss with you. In the meanwhile, you can, type the questions in the chat box. Yes, go
Sir,
ahead. Yeah.
yes, yes, sir. Previous law and the earlier act, and earlier act and the latest act. Sir, what is the difference between two terms?
Earliest act and latest act. Latest act is the recent legislation.
No, sir.
Earlier act.
No, no, sir. Second term consider stated and the previous law. Sir, it is a previous law and second term is earlier act and the latest act. Two terms, sir.
Yeah, so previous law and earlier act is the same thing. There is no difference between that. It is just a different term used for the same thing.
And sir, proviso in the inter acts as exceptional and saving clauses.
Yeah, so proviso is basically saving clause is different and proviso is different. As you can see, saving clause basically saves a certain thing, but proviso basically is not saving anything. It is trying to give you an exception kind of a thing. Okay. But when you use the word exception, it is basically to restrict the clause, particular cases, particular situations. Whereas in case of proviso, it may restrict, it may not restrict. But it is trying to give you a different situation altogether. Let us look at this example. Okay. Section 55 talks about oral evidence, and it says that oral evidence has to be direct. You cannot take indirect evidence in case of oral evidence. And it gives you the situation. These are the four situations in which if oral evidence has to be taken, say, for example, if you want an oral evidence for something which has been seen, then the witness who has seen it has to be brought. You cannot bring someone who has heard a person who has seen. Okay. Similarly, if a fact has to be proved which has been heard, then you have to bring the person concerned who has directly heard it. If the fact has to be perceived by other senses, like say, for example, touch, someone felt, then the person who felt it has to be brought. Mostly in case of this, outraging the modesty of the woman, these kind of situations will come. So there the woman has to explain that is why they have to be brought and they have to be told. An opinion or the ground on which the opinion is held, it must be evidence of the person who holds that opinion on those grounds. So say, for example, I give a legal opinion to you on an issue. You cannot just carry that particular legal opinion and court will accept it. So for oral evidence, the person that if I have given the oral opinion, I have to go there and, give my opinion. Like, for example, doctor's opinion is taken in court, right? But all these situations have been given an exception here. Not exception, sorry, proviso here in these two proviso. These two proviso, what they say that above we have said everything, but okay, provided further if the oral evidence refers to existence or condition of material thing other than a document, then the court may, if it is required, they may ask for that particular material. Like I gave you example of murder weapon. Similarly, provided that the opinion of experts expressed in a treatise, if a treatise is there on which
commonly offered to sale and the grounds on which such opinions are held. Let's say, for example, there is Sirvai's constitutional law book. Now, Sirvai wrote that particular book. Now he is no more, and he has given an opinion on that. Then can you bring Sirvai there? No, you cannot bring Sirvai. But okay, fine. What you can bring that particular treatise to help, or to explain that particular situation. This is what is provision. But when you are talking about an exception, let us look at the exception. Exception here, I gave you an example of Section 300 of the Indian Penal Code, which gives exception in case of murders, which are the situation in which it will not be considered as murder. This is an exception. Like, for example, grave and sudden provocation. This is an exception to the general clause of murder, right? So I hope this clarifies the situation to you. Okay. Is any other question which you have or anybody else has? Okay. Somebody has a question on pari materia. I think I explained that before. Give me a second. Okay. So the pari materia basically is a Latin term on the same subject matter. So when you are interpreting statutes and laws, you will try to see the statute pari materia, you will try to read them together. Like, say, for example, if you want to try to understand the latest Digital Data Protection Act. So Information Technology Act will be a pari materia legislation to that. Okay. That is similar in nature. Similarly, IPC is a pari materia legislation for CRPC, similar in nature, because for finding out the criminal offenses, you look at these legislations together. I hope this clarifies the point on pari materia. CRPC is Criminal Procedure Code. CPC is Civil Procedure Code. Okay. Yes. Any further questions? Any one of you? Okay. Okay, then if there are no questions, all the best for your examinations. I think we have completed this particular syllabus on other laws. Best of luck. I think nowadays you people are having a lot of material to read and understand. In interpretation of statutes as well as General Clauses Act, my suggestion would be that prepare brief notes and brief pointers on each of these particular concepts, which is mentioned in your syllabus. That will be helpful. And remaining, you can always put up your own example. So many a times what happens is when we memorize example from other sources, we don't remember it. So if you can memorize the example from your own source, then that will be easier for you to explain the things in a simpler language. Don't bother about case laws, because I don't think for you people the case laws would be so important. But if you can remember them, nothing like it. So this is what was from my side. All the best. If there are no questions, thank you. Have a nice evening, all of you. All the best. Over. Thank you. Good night.
Recording stopped.